questions of jurisdiction and standing, abstention and venue highlight the important role the justices play in defining how the lower federal courts function. There are several of these decisions this term, and sometimes the questions briefed by the parties belie the importance of the final decision. Suzanna, you think one of our first case did that?
I do. The case is Lexmark International versus Static Control Components, and the simple question before the court was whether Static Control had standing to sue Lexmark for false advertising under the Lanham Act. There's a split in the circuits, and the court was going to decide, and did decide, the analytic framework for standing. There was no question that Static had standing under Article 3, but Lexmark argued that Static lacked prudential standing to bring the lawsuit.
So, Evan, how is prudential standing defined?
Well, the court cited one of its earlier decisions in which it had said that prudential standing is not based in Article 3, and while it didn't exhaustively define prudential standing, nonetheless, it cited three basic principles or strands or whatever you want to call them, one of which is the general prohibition on a person raising another person's legal rights, also known as the prohibition against third-party standing. A second one would be the so-called prohibition against generalized grievances. And then the third would be the so-called zone of interests requirement. That is to say, the requirement that a plaintiff's complaint fall within the zone of interests that's arguably protected by the statute in question. And here the court found that Static suit did fall within the zone of interests that was protected by the Lanham Act.
And that's where the decision becomes so much more important than the original question brief. The court said it declined to analyze the zone of interest as a prudential standing issue. Instead, they suggested it was a question not of standing, but of whether Congress created a cause of action. Indeed, they suggested that the whole idea of prudential standing, the nomenclature, is misleading. They turned what used to be a standing issue into essentially a merits issue.
Yeah. The court also said in dicta that the prohibition against generalized grievances is compelled by Article 3 and that it's not a matter of prudential standing.
And so with that, I think this case suggests that 2 out of the 3 prudential limitations are no longer prudential. One of them is a statutory question now, and the other, as Evan just pointed out, is a constitutional question. And I think this is part of a 20-year trend of the court moving what used to be prudential limits and turning them into either constitutional or statutory questions.
But I'd point to the third there, and that's the prohibition against third-party standing. I don't see the court as eliminating that. There's too much case law about it over too long a period of time. In fact, there's a footnote in this case that specifically says that the issue of third-party standing was not raised and was not being analyzed by the court.
Thank you. A second standing case arose in Ohio. The Susan B. Anthony List, an anti-abortion advocacy group, sued in federal court seeking an injunction against the enforcement of an Ohio law that made it a crime to utter a false statement concerning the voting record of a candidate or public official. The SBA had said that Representative Stephen Dryhouse had voted for taxpayer-funded abortion when he voted for the Affordable Care Act. The Ohio Elections Commission found probable cause that the group had violated the law. The SBA claimed the law violated its First Amendment rights. Dryhouse withdrew his administrative complaint after he lost the election, but SBA maintained its action for injunctive relief, claiming that it would want to make similar statements in the future about other candidates who voted for the ACA. So did they still have standing to sue, Evan?
The Supreme Court said yes. The court held unanimously that SBA had suffered injury in fact that was sufficient to satisfy both standing and ripeness. The question in this type of case is whether the plaintiff still faces a credible threat of enforcement. And the court said that there was a 3-part test for determining that. One, does the plaintiff intend to engage in conduct that's arguably affected by a constitutional interest? Number 2, is the plaintiff's conduct arguably prohibited by the law in question? And number 3, is the threat of enforcement substantial? And the court answered yes to all three of those questions here. The SBA proposed to engage in political speech, which is afflicted with a constitutional interest. Its speech was covered by the statute, and the threat of enforcement was substantial, especially given the fact that the Commission had already found probable cause to conclude that SBA had violated the statute.
Okay, now let's talk about Sprint Communications versus Jacobs. It's about abstention under the Younger Doctrine in civil cases. The Younger Doctrine refers to the Court's 1971 decision in Younger v. Harris, in which the justices held that when there's parallel pending state criminal proceeding, federal courts must refrain from enjoining the state prosecution. Over the years, the Court has expanded the Younger Doctrine to civil cases, but has been careful to cabin that expansion. So, Suzanna, how should the courts make that decision?
Well, the Court says here that federal courts should abstain under Younger in only three kinds of exceptional cases. First are ongoing state criminal proceedings. The second are state civil enforcement proceedings, quasi-criminal proceedings. And the third are civil proceedings that implicate the state's ability to perform its judicial functions.
And how does that apply to the facts in the Sprint case?
Here, the Iowa Utilities Board had ruled that Sprint Incorporated had to pay access fees to Windstream Iowa Communications. Sprint filed suit in state court to get review of the board's decision, and then filed suit in federal court claiming preemption. But the federal court abstained under the authority of Younger versus Harris. The Supreme Court ruled that, number one, the state court review of the board proceeding was not criminal in nature. So that's the first point that Suzanna mentioned. Number two, it didn't involve orders that were meant to preserve the court's ability to carry out their own functions. So that was the second point you mentioned. And then third, the action was initiated by Sprint and not by the state, and there was no state actor who ever performed an investigation or lodged a formal complaint. So that's strike three.
Okay, now we have two personal jurisdiction decisions. The first is Daimler versus Baumann. In Daimler, residents of Argentina sued Daimler in the U.S. District Court for the Northern District of California under the Alien Tort Statute and the Torture Victim Protection Act. They charged that they and/or their relatives were victimized in Argentina by a collaboration between Mercedes-Benz Argentina, a subsidiary of Daimler, and Argentine security forces. Jurisdiction of their lawsuit was predicated on the California contacts of Mercedes-Benz USA, another Daimler subsidiary. Daimler itself is incorporated in Delaware and has its principal place of business in New Jersey. So the question for the court was whether the Due Process Clause of the 14th Amendment precludes the district court from exercising jurisdiction over Daimler in this case, given the absence of any California connection to the atrocities, the perpetrators, or the victims described in the complaint. So, Suzanna, how did the court answer that question?
Well, let me go back to the district court first. The district court had found that there was general jurisdiction, general personal jurisdiction over Daimler based on the subsidiary's activities in California, and the Court of Appeals upheld that judgment. But the Supreme Court reversed. And the court said that general jurisdiction requires much more than just extensive activities or doing business in a state. The test is not whether defendants' contacts with the forum are in the abstract continuous and systematic, but whether they are so continuous and systematic that the corporation is, quote, at home in the forum. And that requires much more than just doing a lot of business in the state.
Okay, in law school, we all heard a lot about the minimum context standard from International Shoe versus Washington. Why isn't that the standard for personal jurisdiction here?
Well, you have to remember the difference between specific jurisdiction and general jurisdiction. The court here emphasized that International Shoe furnishes the test only for exertions of specific jurisdiction, where the defendant's contacts with the state are substantially related to, the facts underlying the plaintiff's case. In this case, the court is reaffirming the approach to general jurisdiction that it set forth in the Goodyear Dunlop Tires operations case, where it said that a defendant's continuous activity in a state, when it's unrelated to the plaintiff's cause of action, doesn't necessarily subject it to jurisdiction.
Thanks. In our second personal jurisdiction decision, Walden versus Fiore, the question was whether actions by a DEA agent in Georgia towards residents of Nevada created personal jurisdiction over the agent for a Section 1983 suit in a Nevada in a Nevada district court. So, Evan, did they?
No. The defendant Walden had confiscated a large amount of money from Fiore and her partner at the Atlanta airport, believing it to be drug money. In fact, Fiore and her partner were professional gamblers, and this was their traveling bank. They returned home to Nevada and eventually got the money back from the DEA, but they sued Walden on a number of grounds. The district court dismissed the claim for lack of personal jurisdiction, but the appeals court reversed, and the Supreme Court held that Walden lacked the minimum contacts with Nevada that were necessary to assert specific jurisdiction consistent with the Due Process Clause.
This case is important because it clarifies one of the court's earlier cases, Calder v. Jones. Fiore had argued under Calder v. Jones that because the effects of the agent's activities were felt in Nevada, the Nevada court had jurisdiction, and Fiore argued that the court had found the effects test sufficient in the 1984 case in Calder v. Jones, but the court distinguished Calder, limiting it and cataloging a number of actions that were taken by Calder that created sufficient contacts. So I think the effects test is going to be harder to show now.
Yeah, the court really emphasized that the relationship between the forum state and the defendant has to arise from contacts that the defendant himself creates with the forum state, and they can't just arise from contacts with people who live in the forum state, and in particular, not just contacts with the plaintiff.
Next, we have two companion decisions dealing with the awarding of attorney's fees in patent cases. These are Octane Fitness versus Octane Health and Fitness and Highmark versus All Care Health Management Systems. So, Suzanna, what are the effects of these decisions?
Under the relevant statute, 35 U.S.C. Section 285, courts are allowed to award attorney's fees to the prevailing party in patent cases only in so-called exceptional cases. Now, the Federal Circuit had interpreted exceptional cases to mean that fees could only be awarded in two circumstances. Either if the attorney engaged in material inappropriate conduct in litigation, or if the litigation was both objectively unreasonable and subjectively brought in bad faith. So in Octane, the Supreme Court held that that formulation was too rigid and that it constrained the district court's discretion. It should be in the district court's discretion to award fees whenever it finds that the case is exceptional. The previous standards still apply, but the court has to apply them on a case-by-case standard under the totality of the circumstances.
And then in the Highmark case, the Supreme Court said that district court rulings on attorney's fees under Section 285 are to be reviewed on an abuse of discretion standard. But in a footnote, the court emphasized that the mere use of the abuse of discretion standard doesn't necessarily preclude an appellate court from correcting legal or factual errors that are made by the district court.
Well, now a third decision involving attorney's fees, but this time focusing on their effect rather than when they can be granted. The decision is titled Ray Holic Gravel Company versus Central Pension Fund. Holic was sued by various union benefit funds under a collective bargaining agreement for contributions they claim Holic should have made. Central Pension Fund was awarded less than they requested in district court and failed to file a notice of appeal within 30 days of the district court's decision on the merits. But it did file a notice to appeal within 30 days of the district court's later ruling on attorney's fees and costs. The Court of Appeals ruled that the fund's appeal was timely because under the collective bargaining agreement, entitlement to attorney's fees was part of the merits. But Evan, did the justices agree with this?
No, they unanimously disagreed. The court cited its 1988 decision in Budinich versus Becton Dickinson and Company, in which the court held that a decision on the merits is a final decision within the meaning of Section 1291 of the Federal Judicial Code, even if the award or amount of attorney's fees for litigation is still to be determined. The issue in Holic was whether it ought to make a difference if the unresolved claim for attorney's fees is based on a contract theory instead of a statutory theory or in addition to a statutory theory. And the justices said it really doesn't make a difference because a rule of finality that were to distinguish between fees claims based in whole or part on a contract as opposed to those based in whole or part on a statute, that any such rule would lack operational consistency and predictability.
Okay. Well, to understand our next decision, you have to know three things about securities fraud class action suits. First, the plaintiffs have to prove that they relied on the defendant's fraud in the transaction that lost them the money. Second, to be certified as a class action, common questions of law or fact must predominate over the individual ones of class members. The problem here is that if each member of a class had to prove reliance, a class could never be certified. So the third thing you need to know is that in 1988, in a decision titled Basic versus Levenson, the court created what is called the Fraud-on-the-Market Presumption. This presumption is based on the notion that in an efficient market, the price of a security reflects all known public information. So the plaintiff is presumed to have relied on the defendant's fraudulent public statement in buying or selling the security. However, the plaintiff still needs to prove the presumption applies in its case by proving that the misrepresentation was public, it was material, that the market was efficient, and that the plaintiff's transaction took place between the time the alleged fraudster made the misrepresentation and the time it was revealed to be false. Later, at the merits stage of the class action, the defendant could rebut the presumption by proving that even in an efficient market, the defendant's particular misrepresentation did not affect the stock price. That is, there's no so-called price impact. Okay, with all of that in mind, let's talk about Halliburton versus Erika P. John Fund. Evan, what were the questions raised here?
Well, Halliburton really wanted the basic decision overruled. Halliburton argued that a number of intervening events made basic unsound. They argued that research on securities markets and subsequent court decisions on class certifications had really undermined the basic rationale of basic. But the court declined to overrule that case. The majority said that those developments didn't rise to the level of special justification, which is necessary to overrule, a matter of statutory interpretation. The majority pointed out that Congress has been active in this area, passing a number of laws relating to security suits and to class actions, but they've never, sought to overrule the rule of basic.
But what the court did do was to allow defendants to introduce evidence of price impact at the certification stage in these securities cases and not have to wait until the class is certified and you reach the merits stage. The court reasoned that the fraud on the market theory was really just an indirect way of showing that there was a price impact, and so it made sense to allow the defendant to demonstrate that there was no price impact, that the misrepresentation had no effect. And if there was no price impact, then each plaintiff will have to prove individual reliance in some other way, which means that individual questions will predominate, and that means the class can't be certified, so it makes sense to allow that evidence at this point.
Okay, thanks. Well, like Halliburton, the court was unanimous in deciding Mississippi versus AU Optronics. The court decided that a state cannot file a suit as the sole plaintiff under the Class Action Fairness Act, or CAFA, which includes a claim for restitution based on injuries suffered by its citizens. Such a suit does not constitute a mass action under CAFA, the court said. So, Evan, what were the facts here?
Mississippi sued companies that manufacture LCD displays, that is, liquid crystal displays, alleging that the companies had formed an international cartel to restrict competition and to raise prices. The state filed the suit in state court and claimed that the company's actions violated two different Mississippi laws. The companies filed notice to remove the cases to federal court, arguing that the case was either a class action or a mass action within the meaning of CAFA. Both the district court and the Fifth Circuit ruled that it was a mass action filed on behalf of 100 or more people. But the Supreme Court didn't see it that way.
No. The court held that Mississippi, because Mississippi was the only named plaintiff, the suit was not a mass action under CAFA. Justice Sotomayor wrote for the court, and she said that 100 or more persons in CAFA doesn't include unnamed real parties in interest. If Congress had meant that, they would have said it. They would have used broader language, as they did in various other sections of CAFA. And she pointed out that if there were no other parties in the suit, the language that required that all the claims joined involve common questions of law or fact wouldn't make any sense. And finally, she suggested that expanding the definition of mass action in the way that the defendants wanted here would lead to a logistical nightmare, including such things as trying to figure out which of the plaintiff's claims satisfied the jurisdictional minimum.
So it sounds like this case really matters in clarifying what is a mass action under CAFA. I mean, if the case had come out the other way, then any suit that would benefit a large number of plaintiffs would be deemed a mass action. And the court says instead it's not those who benefit, but those who are actually part of the lawsuit.
That's exactly right.
Okay. Well, sometimes the court's decisions are subtle, complicated, and nuanced, and other times they're meant to send a strong and clear message. Our next decision, Atlantic Marine Construction Company versus U.S. District Court for the Western District of Texas, is one of the latter group. And the message here is that rules on venue may not be used to circumvent valid forum selection clauses in contracts. Atlantic Marine is a Virginia company that contracted with the J. Crew Management Company in Texas for work on a construction project. The contract had a valid forum selection clause that said any disputes would be litigated in Virginia. But when a dispute arose, J. Crew filed an action in federal court in Texas. Atlantic Marine moved that the action be dismissed under 28 U.S.C. Section 1406A and Federal Rule of Civil Procedure 12b-3. Alternatively, it asked that the case be transferred to the Eastern District of Virginia under Section 1404A. Evan, how did the court rule?
Well, it agreed with Atlantic Marine on the result, but it did not agree with most of the reasoning. 1406A allows transfer when a case is filed in the wrong division. And Rule 12b-3 allows a defense to claim relief by pleading improper venue. The court said that neither of those sections applied because venue is only wrong or improper if it's inconsistent with the venue statutes. It's not wrong or improper just because it's inconsistent with a forum selection clause.
But here's where the court sent the message. It said that the forum selection clause could be enforced under Section 1404A, which allows a court to transfer venue for the convenience of the parties or witnesses to any district where it could have been brought or where there's consent. And in fact, the court said that the trial court should ordinarily transfer the case when there's a valid forum selection clause, unless there are extraordinary circumstances unrelated to the convenience of the parties.
But did it define extraordinary circumstances?
No, it didn't. But it did say that they had to be related to public policy, because once there's a forum selection clause, the plaintiff's choice of forum should be given no weight, since the plaintiff had already agreed to the chosen forum. So basically, a forum selection clause is almost always going to be dispositive.
And could I just add here that the court also said that when a party violates a forum selection clause, the ensuing transfer of venue under 1404A does not carry with it the original venue's choice of law rules. Changes of venue usually do, but the court says that in this situation, such a rule would encourage forum shopping by the plaintiff.
Thank you. There are no questions, so now let's take a look at some federalism and separation of powers decisions.
General, would you agree that this clause now is not mostly used to deal with emergencies arising from congressional absence? that most modern presidents, and I say this sort of going back to President Reagan, presidents of both parties, essentially have used this clause as a way to deal not with congressional absence, but with congressional intransigence, with a Congress that simply does not want to approve appointments that the president thinks ought to be approved.
It is hard to believe that after more than 200 years and hundreds of decisions, there's any part of the U.S. Constitution the Supreme Court hasn't addressed. But that happened this term when, for the first time, the justices interpreted the president's power to make recess appointments. Normally, the president must obtain the advice and consent of the Senate before appointing an officer of the United States, but under Article 2, Section 2, Clause 3 of the Constitution, the President shall have power to fill up all vacancies that may happen during the recess of the Senate by granting commissions which shall expire at the end of their next session. Now, the extent of this authority was challenged in a case titled NLRB versus Noel Canning. During a 3-day Senate recess in 2012, President Obama appointed 3 members of the National Labor Relations Board. Later that year, the NLRB ordered Pepsi Cola distributor Noel Canning to execute a collective bargaining agreement with a labor union and to make employees whole for any losses. Now, Noel Canning challenged the ruling on the grounds that the appointments the president had made were invalid because the 3-day adjournment was too brief to trigger the recess appointments clause. Suzanna, how did the court decide this one?
Well, actually, they addressed 3 questions. First, how long does a recess have to be in order to trigger the recess appointments clause? The second is, does the clause apply to both intersession recesses, that is between sessions of Congress, and intra-sessions recesses, that is within one session of Congress? And the third question is about the vacancy, whether the vacancy has to occur, has to arise during the recess, or whether it can be a vacancy that arose earlier, but the position is still vacant during this recess. So in order to answer these questions, the court looked at not only the original intent of the founders, but very importantly at the historical practices of presidents and Congresses as these questions have come up since the founding. So they ended up with a 4-part holding. First, they held that as to inter and intra-session recesses, the clause applies to all of them. Any kind of recess, the clause applies to. But, and this is the second part of the holding, it only applies to substantial recesses. And the court said that a substantial recess has to be more than 3 days long, and usually it has to be more than 10 days long, unless there is some sort of national emergency, in which case a recess of between 3 and 10 days could trigger the clause. Third, the recess appointments clause applies to all vacancies, whether they arise during that recess or whether they arose earlier but are still open during that recess. And then finally, the court held that because the Senate was during this time holding periodic pro forma sessions every 3 days, that meant that the Senate was never in recess for more than 3 days. 3 days is too short for it to trigger the recess appointments clause, which meant that the president couldn't make those appointments. The appointments were invalid, and therefore the board's decision against Noel Canning was invalid.
Thanks, Suzanna. Now, Erwin, there was a concurrence in the judgment. Tell us about that.
Justice Scalia wrote the opinion concurring in the judgment, joined by Chief Justice Roberts and Justices Thomas and Alito. These justices would have imposed much more significant limits on the president's recess appointment power. These justices said that the recess appointment power applies only for intersession recesses, not for intrasession recesses. And these justices would have said, like the D.C. Circuit did, that it must be vacancies that occur during those recesses. Justice Scalia, writing for these justices, said, the historical record is at best ambiguous, and it should not be able to be used to ignore the text of the Constitution. I think what these justices were concerned about is that the majority had taken a narrow power of the president and given the president much more authority to undermine the Senate's responsibility for approving presidential nominees.
What's the implication of this?
Well, I think there's at least one interesting political implication, which is that the Senate can prevent recess appointments by simply holding pro forma sessions every 3 days.
And if the Senate does that, that may lead the president to invoke another constitutional provision that's never been invoked and never been construed. There's a provision in Article 2, Section 3 of the Constitution that says if the House and the Senate cannot agree as to a recess, the President may call a recess of Congress until such time as the President calls Congress back in session. So if Congress doesn't go into recess, the President wants to make recess appointments, might invoke that provision, and that could lead to cases we will talk about in the future.
But I think it's also important to note that this case was in some sense a win for the president. It sometimes is portrayed as not, but remember the D.C. Circuit and the dissenting justices wanted to narrow a president's recess appointments much more than the majority ended up doing.
With our next decision, we go from issues of high constitutional principles to more meat and potato questions of federalism, albeit in a complex statutory context. The opinion came down as Chadbourn and Park LLP versus Troyes, but it also represents two other cases granted cert which ask the same question. Troyes and others bought bank CDs in part because they were told that those investments were or would soon be backed by high-value investments in the bank's portfolio, including some publicly traded securities. In fact, it was a Ponzi scheme, and the main perpetrator was eventually convicted of securities fraud and sentenced to 110 years in prison and subjected to forfeitures and fines totaling $12 billion. So Troyes and other plaintiffs brought state law class actions against some of the perpetrators. Some of the cases were brought in federal court and others were removed from state to federal court. And in the end, a single judge in the Northern District of Texas heard all the actions. Now that court dismissed the suits for violating the Securities Litigation Uniform Standards Act of 1998, which prohibits plaintiffs from maintaining a class action based on the statutory or common law of any state in which the plaintiffs allege a misrepresentation or omission of a material fact in connection with the purchase or sale of a covered security. Now, covered security is defined as only securities traded on a national exchange. So, Suzanna, were these suits prohibited under SELUSA?
No, they were not. The Supreme Court said that the statute doesn't apply and the plaintiffs can go forward with their suits in either state or federal court. Justice Breyer's opinion said that the primary question in the case was the meaning of that phrase, misrepresentation or omission of a material fact, in connection with the purchase or sale of a covered security. And the court said that the connection between the purchase or sale and the security had to be tighter than it was in this case. It wasn't enough that the misrepresentation was that the CDs would soon be backed by publicly traded securities.
And the implications of the decision?
I think because the court narrowly interpreted the statute, there's going to be more state securities class actions based on state law.
I think it's important to remember, though, that this is a case just about private suits under this statute. This doesn't apply to criminal or civil enforcement actions brought by the Securities and Exchange Commission. Their securities fraud is defined more broadly, and securities would include these certificate of deposits.
Thank you. We'll be right back to talk about bankruptcy.
The court decided a number of important bankruptcy decisions this term, including Executive Benefits Insurance Agency versus Artisan, which was anticipated as an important follow-up to the court's decision in Stern v. Marshall a couple of terms ago. I recently had a chance to talk about Artisan and the court's other bankruptcy decisions with Professor Michelle Harner from the University of Maryland Francis King Carey School of Law. Michelle, as always, it's great to see you, and I really thank you for being here today to talk with us about the 3 bankruptcy decisions this term. I'd like to start first with the case that most people waited for all year, and that's Executive Benefits Insurance Agency versus Artisan. I think that this case was so highly anticipated because its potential impact not only on the bankruptcy system but on the magistrate system, because it called into question bankruptcy judges' authority to hear certain types of claims even with the parties' consent and to enter final judgment on those claims. So the issue was set up by Stern v. Marshall back in 2011. Can you describe the issue a little bit more for us?
Absolutely. This certainly was a sequel to Stern versus Marshall. And in Stern versus Marshall, what you had was the Supreme Court deciding that even if the statute, so here it would be 28 U.S.C. section 157B, designates a claim as core, which means the bankruptcy court could decide it by final judgment. If the bankruptcy court lacks constitutional authority to decide that type of claim, it simply cannot render a decision. So you had this situation where 157B lists a whole, set of different types of claims as core, including counterclaims, which was at issue at Stern, and fraudulent transfer claims, which is what is at issue in the current Supreme Court case. And when the bankruptcy court lacked constitutional authority to resolve that type of claim, the circuit court split on what happens. Could the bankruptcy court do anything? Could it enter proposed findings and conclusions of law? Or did that matter simply have to go to the district court?
So what did the court decide about this?
So, it's interesting. It certainly was anticipated, but I've heard so many people say they were relieved because, as the court hinted to in Stern v. Marshall, it wasn't changing the landscape much. But there was also, I think, a great sense of disappointment about the decision, primarily because it left several open issues. But with respect to what the court did in the Artisan case, it basically said there's no statutory gap. If you have a claim designated as core under Section 157B, but the bankruptcy court lacks constitutional authority to decide that type of claim, we simply invoke the severability provision of the statute. We take it out of 157B. We drop down to 157C, which talks about claims that are not core. So the court said here, when this fraudulent transfer claim dropped out of Section 150CB because it was a, quote, Stern claim, the bankruptcy court still had authority under 157C because it was not core and it related to a case under Title 11, so the court could enter proposed findings of fact and conclusions of law, and that's how the district court treated the bankruptcy court's order, and it also reviewed on a de novo basis the issues that had been timely and specifically objected to by executive benefits. So no problem.
Right after the decision, I certainly read what the court decided, but I think I read more about what it didn't decide. And I think you're right. People were waiting for more. What are those issues, and what do you think is going to happen?
So I think the disappointment came from the lack of resolution of the consent issue. So right now, if you look at 157C, not only can a bankruptcy court enter proposed findings and conclusions on not core claims, but also if all of the litigants consent, the bankruptcy court can enter final judgment. And there was a split in the circuits, and there still is a split in the circuits, with the Ninth Circuit holding that consent of the litigants, even implied consent, is sufficient to allow the bankruptcy court to enter final judgment, but you have the Fifth, Sixth, and Seventh Circuits saying no. This is a structural issue under Article 3, and consent, even consent of all the litigants, does not resolve that constitutional issue. And so we have this unanswered question with huge implications, because as you referenced earlier in your comments, it also affects the magistrate system here.
So we're going to have an interesting few years coming up, I think.
We will, but fortunately the Supreme Court granted cert on the Seventh Circuit Wellness International versus Sharif case, and that will possibly give us more guidance on consent, because that is one of the issues in that case.
Okay, well, let's move on to the next case, and that is Clark v. Ramaker. Okay, the petitioners in this case had filed Chapter 7, and they had claimed as exempt a retirement fund that one of them had inherited from a parent.
Yes.
And as a consequence, if it was exempt, it wouldn't be available to pay creditors. They relied on a statute that exempted retirement funds that were kept in certain kinds of accounts. What did the Supreme Court say about these kinds of inherited retirement funds?
So what the Supreme Court did, and it was actually something done in all three of the cases before it this term, it took a very close look at the statute at issue and said we're dealing with Section 522B3C of the Bankruptcy Code, which says a debtor can exempt from a creditor's reach, quote, retirement funds that are exempt from taxation under the Internal Revenue Code. And the court dispensed with the second part of that requirement very easily because the inherited IRA is a tax-exempt account under the particular provisions of the IRC referenced in the exemption statute of the Bankruptcy Code. So the whole decision turned on the term retirement funds. And the court said it's not defined by the Bankruptcy Code, so let's look at its plain meaning. And the court said usually we think of retirement funds as funds you set aside for when you stop working. And there were three characteristics of the inherited IRA that the court found took it out of that type of savings account. First, the holder of the inherited IRA could not invest more money in the fund. Second, the holder was mandated by statute to withdraw funds even if she didn't reach retirement age yet. And finally, the holder of the inherited IRA could withdraw the entire amount at any point. So it was hard to say she was saving that for her retirement years. Because of that, the court said the statute simply does not allow you to exempt it, and in doing so thought about the balance Congress struck between allowing a debtor a fresh start with the exempt property and also maximizing value for creditors from the estate's assets.
So the practical implications of
here it's really interesting because both the lower court below and the Supreme Court recognize the difference between an inherited IRA that a spouse receives from his or her husband or wife and rolls into, her own IRA as a retirement fund, and an inherited IRA from a non-spouse that you simply have to hold in that form. The latter, not exempt. When you roll it into your own account, certainly exempt.
So something for some financial planners to take a note
Absolutely.
of, for sure. Let's move on to the final case, Lavi Siegel. This case involves some very egregious behavior by a Chapter 7 debtor who claimed a fraudulent second mortgage on his home. Between the $75,000 homestead exemption, the first mortgage, and the second mortgage, the trustee couldn't sell the home and to recoup any money to pay the debtors. The trustee, after months and $500,000 of attorney's expenses and legal expenses, proved that the second mortgage was fraudulent. The bankruptcy court then surcharged the $75,000 homestead exemption so that the trustee could recoup some of the expenses. What was the bankruptcy court's reasoning in doing this, and did the Supreme Court agree with it?
So it's interesting. You had a bad actor here, and the bankruptcy court tried to remedy his conduct by saying because the surcharge on the exempt property was to compensate the estate for an actual loss, it was an appropriate remedy under the Bankruptcy Code's Section 105 equitable powers. Supreme Court completely disagreed and said what you have here are two sections, again, of the code we have to think about carefully. You have Section 105 that says the bankruptcy court can issue an order that is necessary or appropriate to implement the provisions of Title 11. But you have Section 522K that specifically says, except for one circumstance, you really can't use exempt property to pay administrative expenses. Trustees' fees are administrative expenses generally, so the court said you can't do it and you can't use 105 to get there. So we saw the court really recognizing a limitation on the bankruptcy court's equitable powers.
Okay, so just real quickly, do you think this case has anything to say for the bankruptcy court's general authority under 105?
I think it's consistent with the prior case law from the Supreme Court, and I think if the bankruptcy code is silent or there is ambiguity in the code, Section 105 helps a bankruptcy court issue a necessary or appropriate order. But if you have an explicit provision under Title 11, the Supreme Court's going to be very limiting in what the bankruptcy court can do.
Okay. Well, thank you very much. I really appreciate, again, you being here today, and I hope we get to talk again soon.
Thank you.
And finally, patent and copyright decisions this term resulted in one company going out of business and another being forced to pay damages for its marketing of a classic movie. Professor John Thomas of Georgetown University Law Center came by our studios recently to talk about those and other decisions in this area of the law. Professor Thomas, thank you for joining us. Let's get started right off with the Medtronic versus Moravsky case. Medtronic brought a declaratory judgment action against Moravsky, asking the court to declare that its products did not infringe on Moravsky's patents. As the plaintiff, now Medtronic would normally have had the burden of proof, but because Moravsky was the patent holder, who usually has the burden of proving infringement in a patent infringement case, the question before the court was who had the burden of proof in this patent law declaratory judgment case. And the court decided that Moravsky, the patent holder, had that burden. Can you explain the relationship between this decision this year and the MedImmune case back in 2009?
Right. A few years ago, the Supreme Court issued its opinion in MedImmune. And that case held that under the Declaratory Judgment Act and under the Constitution, a case or controversy existed for an individual that was paying license fees under an agreement. This allowed the patent licensee to have its cake and eat it too. It could pay the royalties and be safe from charges of infringement, but also bring a declaratory judgment action seeking that the patent become invalid. So the court's reasoning in both MedImmune and Medtronic was animated by this notion that licensees are the individuals most interested in having patents struck down, and they ought not to be muzzled in any way. So the Medtronic case allows parties to bring declaratory judgments seeking patent invalidity and not have to face the burden of proving non-infringement. Rather, the patentee is still put to its proofs. So the policy goals are the same.
Right. Now, we're discussing this case in the context of other patent and copyright cases, but we might just as well be discussing it in the context of a civil procedure discussion. Isn't that right?
Right. The judicial opinion mostly focuses on the civil procedure aspect. The court was particularly concerned that if the lower court's holding had been upheld, the judgment would not have preclusive effect. And so therefore, you would still have to have in future infringement cases. So the court mostly looked at it through a civil procedure lens, but there is a nod to the patent policies that we've just discussed.
Okay. Let's take a look at Alice Corp. Alice Corp held patents for software that allowed the user to manage risks by facilitating the exchange of financial information between parties using a computer system as a third-party intermediary. Now, using third-party intermediaries has been going on for many years, but those were human, not computer intermediaries, and they were used to manage the risk of non-payment, and that's a business practice that goes back, I guess, hundreds of years, right? The court held here that Alice Corporation's patent was not valid because all it really did was patent an abstract idea, right? So they didn't decide this case on the basis of the Patent Act, though. How did they decide this?
Well, they didn't conform to a tight statutory reading. Section 101 of the Patent Act allows an expansive array of things to be patented. But there are judicial exceptions. The courts have long held that abstract ideas, natural phenomena, and laws of nature can't be patented. The court here was willing to say that dressing up this patent, this idea, and the clothing of the computer system, making it look more technical, wasn't enough for it to get outside the prohibited domain of this common law abstract idea exception to patenting.
Well, this is the fourth case since 2010, I believe, in which the courts held that a patent claim was invalid based on judicial exceptions to patentability. Is that important? Why is that important?
It is important. The Federal Circuit, the Court of Appeals that's tasked with deciding most patent cases, has arguably presided over a steroids or go-go era of the patent system where virtually anything could be patented. The Supreme Court here has continuously stressed a concern about patenting fundamental scientific knowledge and also business transactions like insurance or marketing. This is a strong and continuous and unwavering voice from the Supreme Court that some things ought not to be patented.
Well, can you see any limits on these judge-made exceptions?
The exceptions themselves, abstract ideas, natural phenomena, laws of nature, are pretty old. They've been around for a long time, but they've been interpreted more narrowly in the past. Again, here the court was willing to say, using the art of a patent draftsman, dressing up patents to make them look more like hard tech rather than these basic ideas is not enough. We're going to see past that and say that these things aren't patentable.
How does this case affect patent protection for software?
The Supreme Court declined to say that all software was not patentable. But it's going to be much more difficult to get a software patent, and that affects both pending applications at the Patent Office, but also issued patents that are out and might be subject to challenge. Essentially, unless there is a technological improvement, an improvement to the computer itself, rather than the just use of a general computer, you can't get a patent.
Let's take a look at Petrella versus MGM. Although the Copyright Act has a statute of limitations that requires civil action to be brought within 3 years after a claim is accrued, it also has a separate accrual rule that allows that when a defendant has committed successive violations, each infringing act will restart the statute. So Paula Petrella inherited the copyright to the script for the movie Raging Bull from her father, who co-wrote it. Although the movie was released in 1980, Petrella sued MGM in 2009 for copyright infringement and sought monetary and injunctive relief limited to acts of infringement occurring on or after January of 2006, 3 years earlier. MGM moved for summary judgment under the equitable doctrine of latches. And the court decided that latches could not be used when there's a statute of limitations and found Petrella's claim was timely. Now, will the distinction that the court makes between legal and equitable relief here have much effect on how judges decide future cases?
This case is a big win for copyright owners because copyright terms last a long time, but the commercial value of a work tends to be pretty short. So this would allow infringement suits to be brought even in those circumstances. The opinion leaves the lower courts in the situation they were left in after eBay. Normally the practice was to enjoin infringement and then let the parties work out the deals of how the work to be exploited outside of the courtroom. But here the court said that although the circumstance of latches wouldn't bar the claim entirely, it may limit the ability of the court to grant an injunction as a form of equitable relief. So the courts may find themselves not granting injunctions and supervising judicial damages awards, royalty payments throughout the term of copyright.
All right, and there was one more sort of big case, ABC versus Aereo. The Copyright Act of 1976 gives copyright owners the exclusive right to publicly perform material, copyrighted material. Aereo was a company that used, I think, a dime-sized antenna to allow mobile device owners to watch broadcast programming almost simultaneously with the time it was broadcast. And Aereo argued that it was providing a technology to allow its members to access remotely what was being broadcast for public consumption. In other words, it was not itself performing the copyrighted work publicly. But the court disagreed and decided that Aereo was violating the transmit clause of the Copyright Act. So is this a pretty narrow textual decision?
Not at all, in my opinion. I think that the court engaged in a bit of creative statutory interpretation, saying, for example, that these antennas performed the work. I think that the court saw something that looked like cable TV, but that was skirting the usual payments that cable television providers have to make, and also had fabricated an elaborate Rube Goldberg device solely for the purpose of getting around the Copyright Act.
Well, and Aereo ceased doing business after this decision. So what do you think will be the effect on other future technologies, and how are they subject to, what happens to the claims of copyright infringement of future technologies as a result of this case?
The court said, as it often does in high-tech intellectual property cases, that it was fashioning a very narrow decision. But still, it had a fairly broad construction of terms that would bring in technologies under the mantle of infringement. Nonetheless, this may not impact cloud computing or cloud-based information services as much as some have feared. Cloud computing tends to involve the storage of individual specific files, your files, while the technology that was discussed here didn't. That may be a salient distinction that might still save the cloud. But we'll see. We'll see what the future technologies bring us and what future claims of copyright infringement result in.
Great. Professor Thomas, thanks for joining us.
Thank you for having me.
That's our program for this year. I thank our faculty for their thoughtful discussion. We hope you found the program useful and interesting. Once again, please fill out the evaluation form found on the program's webpage and send it to us. I'm John Cooke. For everyone here at the Federal Judicial Center, thank you for watching.